We always insist our clients have a succession list. So you have a number one, and if number one can't or won't do it, then there's a number two, and then there's a number three. Usually, I don't have clients go beyond three. Usually that's pretty safe.
I know somebody that had 10.
Do they expect to live for a long, long, long time?
Apparently. Life's Third Act is a podcast dedicated to helping you get the most out of your retirement. Sponsored by TuckerAllen, Attorney-CPA Joe Cordell features guests each week to discuss prominent topics for those over 55. Here's Attorney-CPA Joe Cordell.
Welcome to another episode of Life's Third Act. This week we're going to talk about something that is too often neglected. Many people have in place a will or a trust. We talk about that subject every now and then. We come back to it regularly.
Sure. It's good to review.
It's good that we mention TuckerAllen's name regularly.
Of course.
But we want to talk about all things that are important to people who are in what we call kind of the third act, the last third of their life, and things that can make your life much better than it would otherwise be. And among the things that get neglected is it's almost regarded as a detail, even sometimes by estate planning lawyers. And that question is, what happens if whenever things are going fine, perhaps you seem to be in good health, you have no reason to expect to be suddenly incapable of managing your affairs, and then something happens quickly. And it's those cases where it's a single event, such as a heart attack, or it could be a car accident.
Right. Stroke.
All sorts of things can happen, and it's not the sort of gradual loss of health that allows us often to plan. Sometimes we think, we have time to think about doing that later. You've heard us talk about durable powers of attorney. You've heard us obviously talk about wills and trusts. But there are other things. You say to yourself, well, yeah, I know that's important to get that done, but I'll have time to do that if I get diagnosed with an illness, for example, that may be terminal. But all too often, it doesn't happen that way.
Then you're in crisis mode. It
happens in a moment. And then when that moment happens, what is it that you need to have in place? So we think it's worth your time for us to take this show and dedicate to that topic. So this show is not about so much estate planning. This is about latter stages of your life planning. Although, the information we're about to talk about would be just as true for somebody who's 25 or 30.
Right.
I mean, it may be statistically, they may be less likely to have such an event, but the same rules apply.
It could happen.
So let me kind of set this up. Let's assume that you are like most of us, you have bank accounts, you own some real estate, you may even own a second piece of real estate or a third if you have a rental property or you have a vacation home. You have securities probably in 2 or 3 different places. You might have a friend through church that you let handle some of your money, maybe a few accounts. You may have a few investments that you've done just because you knew the people. So maybe you put $50,000 or $100,000 or more into an investment that you did kind of as an unusual decision, but it was just based on somebody that you knew. So I could go down the list of things that would be in your portfolio that you would know about that even people who know you well would not fully know about. And then we can think about, well, what about your 401ks? Where is that managed? Is that managed in one place? Your pension plan. Do you have a traditional pension? A lot of the people watching this show have lived long enough to where you have traditional pensions. Nowadays, I can tell you, as you probably know, it's a thing of the past. I tell my daughters, that at one time when you worked for a company for a certain amount of time, you accumulated the right to receive a certain amount of money, and that payment would go up. And that payment even adjusted that cost of living increase adjustments were not uncommon.
Uh-huh.
And there's still, my brother is on that plan with the government. So some of you will be living off of money that you're getting through some sort of pension. Others, it'll be 401ks or IRAs. Some of you may have bought annuities. So I could go on and on about the unique characteristics that everyone has to some extent with their portfolio. And then let's talk a little bit about, though, the informational side of what exists in your day-to-day life. You probably have a lot of information that's stored on some websites. Now, we may be able to guess what some of those are, and others maybe not. And some of it is important personal information. Some of it may be photos that you've accumulated over many years that you've shared, that maybe whether it's Facebook or another website. I mean, there's lots of information about you and your life that's stored there. You may have a safe deposit box, but you probably have, if you're like many of us, you may do business with more than one bank.
And where's that key?
And where is that? And now a lot of safe deposit boxes are not in banks. There are businesses that exist just to do that, to provide safe deposit places for larger assets, for example. So I could go on to make the point that there's a lot of important things in your life that need attention that somebody will have to take care of if this event that I'm describing occurs. Now, if you've watched this show much at all, you know that we have an answer for how you can have immediately somebody in a position to take the wheel. It's like you're driving a car. You're soaring down the road, you're cruising, everything's great.
Yeah.
All of a sudden you have a heart attack. Well, from a legal standpoint, what a power of attorney does is it allows someone to immediately take the wheel. The vehicle doesn't crash. Instead, they immediately take the wheel and they can continue safely driving as safely and even as effectively as you were doing.
But they have to have that information.
Yeah, they have to have the information. And let's take a step back before that. I've emphasized the information, but let me go back a little bit. For those of you who haven't watched the last show we did relating to the power of attorney, which is the legal mechanism to give them the power to do that. How long ago was that show? Has it been a couple of months?
Probably, yeah.
Yeah, so let me talk just quickly. Some of you are saying, oh, I've heard about a power of attorney, and I know it's a good thing. Let me argue it is a miraculous thing. It's not simply a good thing. It's a miraculous thing.
It's a must.
It's a must, and it's comparatively cheap. A durable power of attorney, if you get one done, you want one done according to your terms. Don't order a form. Go to a lawyer. Hopefully use TuckerAllen. But if not TuckerAllen, go to a estate planning lawyer that knows the various options you have when you're making a decision about what rights to give somebody. Because all these forms are not the same. You would not want to empower someone in the identical way, I'd be willing to bet, as Justin, who's there watching this show and asking himself, do I have this thing in place? But the point is, everybody has some different preferences. There are common themes, so it's not as if there are 1,000 different options. There are 5 to 10 different decisions that you need to make when you're choosing a power of attorney, but those are very important decisions. So spend I don't know what it costs, a couple $100 maybe to get a durable power of attorney done. But once you've done that, you've literally placed beside you someone so that, as using this metaphor, as you're driving through life, someone who you trust to immediately take the wheel. And here's the alternative. If you don't do that, you may say, well, gee, I've heard of guardianships. I've heard of people that can be appointed to do that. Well, that's true. You can do that. Let me tell you about that option. What that option consists of is, we'll use the same metaphor. Driving down the road, there wasn't someone sitting there, so let's assume there's a crash or whatever happens. So you need to get someone in a position to take care of you, your health, and your stuff. We'll assume you're surviving. Well, here's the way that happens in the absence of a durable power of attorney. Somebody files a petition with a court. That means that they had to hire a lawyer, and they couldn't hire initially with your money. They'd use their own money, but it'll end up being your money. So they hire a lawyer. They go down and file a document with probate court. So probate court now sets up a date for them to appear in court, a hearing, and somebody will testify. There may be a disagreement in the family. I can't tell you how many times this happens.
Sure.
I mean, how often is it that siblings think that both of them or all three of them may think that each of them is more qualified to do this.
Oh, of course.
Yeah, and it's a bit of a power struggle, too, because, you don't want it to be. This is a moment when everybody should be thinking about mom, and maybe they are.
And be unified,
They should be unified.
They should be, but that's not reality.
It's not reality, in part because all three of them, we'll use three for example, may think that each of them has a better idea about how to take care of mom. They may genuinely care about mom and distrust the other's judgment or honesty in some cases. So, this is plan B. So if you've not done a durable power of attorney, I'm describing to you your plan B. So whether your kids argue or not, whether there's an agreement or not, ultimately a judge is going to listen to the testimony, make a decision about who should be placed in charge, and the gavel goes down.
And that can take time.
It does take time.
Before it's decided.
Yeah, and whether it's contested will affect that.
Right. So that complicates it even more.
And the court docket, sometimes the docket, you're waiting longer than you otherwise would.
And meanwhile, this person who had this car accident, heart attack,
is in ICU somewhere.
Yeah.
And fortunately, the hospital will, on an interim basis,
that's true,
go ahead and make some decisions because they can't let you die. So that's good news that if you don't have a durable power of attorney, but I can tell you they want a family member that's qualified by law to make this decision. So they're waiting to find out who has the authority to make those really tough decisions, not whether or not when clearly you're capable of recovering. And so as a result, they do procedures that are necessary. It's those discretionary calls. Do you want to be on life support for years? Do you want even CPR to be administered in some cases, or any other form of artificial life support? So there's lots of decisions that the hospital will not want to be in the position to make, and nor should they make. So meanwhile, the courthouse has your life and your welfare in their hands. And that shouldn't give you peace of mind, to be frank with you. But here's another thing that exists for your protection, but ends up being very expensive and very unwieldy. And that's the fact that the court, once that gavel goes down, they appoint someone and says, okay, I've chosen child B to be the one who makes these decisions. So the court says to B, now you have to report back to us regularly. And if you want to do anything exceptional, you need to come to us and we need to approve it, especially if there's any disagreement by your siblings. So you can see what lies ahead. Now, if it's a perfectly harmonious family, maybe there won't be those disagreements, and there'll just be the need to come back to the court and report regularly on how funds are managed. There has to be a report prepared, and you can see why these rules exist.
Sure.
Mean, if you're not going to have a power of attorney, I guess this is what we need, because we want some mechanism to assure that whoever the court appoints is going to handle responsibly your affairs, however complicated they are. And this includes everything. This includes all the bank accounts, your IRAs, the money coming in from pension plan, handling your Social Security checks, filling out the forms to be sure that Social Security now has the right payee, and that process of getting approval through the Social Security Administration is entirely separate from this judicial proceeding, but they will rely, or whatever decision that the state court makes will pretty much reflect what Social Security does. So there's work involved, and so the judge wants to be sure that whoever's in this role is discharging their responsibilities well.
Okay. Now I've got a question. Okay, you give someone power of attorney. That catastrophic event happens, whether it be a stroke or a heart attack. So you're then acting on their behalf. So say you have to go to their bank for whatever reason. And you show the bank you have this power of attorney. Do you have to prove in some way that individual is incapacitated, a doctor's note or something like that?
Well, that raises a good question. And let me take a step back. I'm going to run at that. I'm going to run at answering that question this way. So I think that I've described to you how important it is to have a durable power of attorney. It's a no-brainer. It's not expensive. Doesn't take long to do it. and you can see the sort of potentially hellacious complications if you don't do it. So now here's the reason I wanted to take a step back in answering that is I want to set it up that once you know that you need a power of attorney, then you have to make a few decisions about what it should look like. And as I said a while ago, it's not that there's a long list of things that you have to decide for everyone, but there is a list. It's just that it's not a whole lot of stuff. And you raised just now an important issue that different people will choose different things. Among the things that you want to consider is when do you want it to be effective?
Okay.
So some people say, look, I don't want to give anybody the power to have access to my bank accounts, to my other financial matters, to my stuff, unless I'm incompetent. So I only want this to kick in when something happens, when that event happens that we're talking about, whatever it is. And when you first think about it, many people say, well, of course that's true. Why would I want to give somebody that access earlier? But there is a reason. The reason is that if there's a condition precedent, as it's called, if there is a condition required to trigger this authority, then the whole idea is to keep you out of court. So any good durable power of attorney is going to keep you out of court. But one way they do that is they'll have, for example, 2 or 3 doctors that will attest. And so they'll sign an affidavit in which they attest that you're incompetent. You could have one doctor do that. You could have a panel of your children do that, requiring unanimity, for example, or 2/3, or you can choose the mechanism. And then once that's done, then there's an affidavit executed. The law will protect a financial institution that is given a durable power of attorney, and if it does have such a condition, if there's attached the affidavits that the document requires,
Okay.
if those things are attached, then the law protects that institution. You can see why we have that law is that
Yes.
Yeah, they don't want to hold up what's intended to be a solution
Right.
to people at a very vulnerable point in their life. But here's the counter argument. Number one, let me make this point. If you cannot trust this person when you're competent,
Very good point.
should you trust them when you're incompetent? So that is a critical question. If you've chosen someone that you don't feel comfortable, if you think they'll start doing something sneaky maybe while you're alive, then I think I would rule that person out, or while you're competent. I think I'd rule that person out. But here is really the most important reason from my standpoint is assuming that you've picked somebody that you really trust. In other words, they're not going to be looking into your affairs while you're alive. They're going to be going about their own business, but you've made them aware of what's there. We'll talk about that in a minute. And otherwise, they're not going to be intruding, or they're not going to have their nose in things in your life that they shouldn't. And the reason that that's more favorable is if you have a durable power of attorney that has conditions to it, even though the bank is protected, it's still going to go from that first floor entry where perhaps you walk in, you sit down with a bank officer, you provide them this material. The decision to give that person authority to start doing stuff probably will not happen at that moment. I can tell you that for most institutions, it goes from the first or second floor up to the 40th floor, which is where the legal department is, and the legal department reviews it and confirms that these conditions or this condition is met. That's the delay. It's not that that the bank will not honor it. It just produces, varies from bank to bank. It could be 1 day delay. It could be a week delay.
But those safeguards have to be in place.
They probably are, because most tellers, I'll use the word teller, or a divisional representative, a local representative in that branch, generally they're uncomfortable, and many times they're not even authorized to make that call when there are conditions precedent. So if you get rid of those conditions and you say, for example, let's assume it's your sister. You trust your sister completely and totally. And in that case, why put a condition on it when there may be some question about whether or not the incompetence is properly valid, or whether this condition is met? sometimes people will say, I want a panel of 3 doctors. Well, that's a little scary, because it could mean that these doctors' thresholds of incompetency, quite frankly, are either too high or too low.
They may not all agree.
Yeah.
Then what do you do?
And if anything, here's the funny thing about it is they're probably going to err on requiring a whole lot of evidence of incompetence so that so you don't sue them.
Right.
Well, oddly enough, you would almost prefer that they be very sensitive to your competency, have a kind of a low threshold rather than a real high threshold, because in the meantime, you could do harm to you could be making some bad decisions with your retirement funds, for example, and your doctor may not have a good feel for competency and may say, no, I'm not comfortable signing this affidavit. So granted, you can imagine scenarios in both directions. A doctor that's too reluctant or a doctor that's too enthusiastic or acquiescent. I can tell you, you may think, well, gee, this could end up going sideways often. I can tell you, having been involved in this area of the law and related areas of the law for many years, I can count on one hand the time where there was a situation where somebody was falsely deemed incompetent. Now, it would take certainly more than one hand to talk about the occasions where there's been fraud involved. And so fraud is a different subject. But that has usually happened after the person has been given power, and then they charge down the road and do what they want. And incidentally, that is subject to happen whoever is put in charge of your estate. You're far more likely, if you make an informed decision, to choose the person correctly than a judge is.
Right.
But that assumes you think it through properly and you not simply make the decision that you think will cause you less of a headache right now. And that, I'll give you a few examples. When I see that, often it'll be maybe a child that has an expectation, and which should be a big red flag. A child that expects to be in control of things, always has been in control of things, at least among your children, and maybe including you. And so you don't want to offend them. So maybe you tell your lawyer, I want to name that person to be the person who has my power of attorney. I can tell you that often that doesn't work out. Often that turns out to be a bad decision. But it's not that the instrument or the method was wrong. It's that you simply did not use your best judgment. It wasn't you had bad judgment. You didn't use what was your best judgment. Right. And you did it for reasons that weren't related, that didn't tie in with your best interests. And this is a time when you have to think about your best interests for the balance of your life, because it's at that moment, but before you sign that document, that you're making that decision right then and there. But it's good news in the sense that you're competent now and you're clear-headed, and then you're in a much better position to make that decision now probably than you'll ever be.
I really like the point you raised about if you can't trust them when you're competent, forget about trusting them when you're not competent. So it is really important to find that person, and also to list a number of people in case that top person can't fulfill the duty or say they pass away.
Yeah, and you raise a good point. You can list more than one person, and we've talked about that on different shows where some people will have 2 or 3 people or more. The only caveat I would say about that is keep the number low and have an odd number in the event that there's a disagreement. But I will tell you this, it does slow things down. It means that before a decision can be made, others have to be located. So some people still really want to include, both of their kids, for example. It's just that if it does result in a tie, you've got to include a tiebreaker in the document. You don't want it to end up in court. Remember, the whole idea is don't pay lawyers, don't have to spend your money on lawyers and litigation and courthouses. And that's the pathway that exists if something happens and you have a period of incompetency in your life and you don't have a durable power of attorney.
No, what I was talking about, not having them all serve in this role at the same time.
In succession. Yeah, let's talk about that.
And you can do that, right.
You're right, and that deserves mentioning too. It is possible this person dies before you do. So what then? or this person may become incompetent before you two. And who knows? I mean, things happen. And if it's somebody younger than you, it probably was some catastrophic event, such as an accident or something like that. But it does happen. In any case, what Jill's talking about is the fact that we always insist our clients have a succession list. So you have a number one, and if number one can't or won't do it, then there's a number two, and then there's a number three. Usually, I don't have clients go beyond three. Usually that's pretty safe.
I know somebody that had 10.
Do they expect to live for a long, long, long time?
Apparently.
So, I mean, you can do stuff like that. And these are just a few of the things, though, that when you think about a power of attorney, what do you want your power of attorney to be? And yours will be different than a person sitting next to you. Another thing to think about is how much power do you want to give this person? Some people will say, look, I'll let them change anything and everything. I'll even give them power to change my estate planning documents. That's a little scary.
Yeah, I don't think I'd give anyone that power.
Yeah, that is really scary to let someone change your estate plan. You may say, well, why would any lawyer sanction that? Well, for some people who are really worried about tax issues, for example, tax laws change. And if during your incompetency, a new tax law is passed by way of, if there's a way to move your stuff around into a different trust, for example, or to create a trust to move it into, or to take it out of an existing trust, whatever it may be, where you literally would save, if you're a wealthy person, would save millions of dollars for your children, it would be a shame if in that situation that couldn't be fixed. And it couldn't be normally. I mean, normally, if you're talking about a durable power of attorney, a typical provision, if an experienced lawyer were drafting this for you, they would probably caution you against having somebody who can tamper with your estate plan. And usually that includes moving stuff in and out, moving stuff wholesale in and out of a trust. You might have the ability to take money from a trust to pay bills. That's not unusual. Lots of people have revocable trusts. So what we're talking about here will not interfere with your estate planning if you're using revocable trusts. And revocable trusts, incidentally, are a great idea. But revocable trusts are not for tax planning. Now, I mean, if you have less than if you're a married couple and you have less than $22 million, you don't have an estate tax problem. For a single person now, it's 11 point something million. And so you don't have an estate tax problem. Now, it's true that there's lots of talk about lowering that. I mean, we lower way down to maybe where it was. In 2000, I think it was $1 million, believe it or not.
Really?
Yeah. And nowadays, lots of you watching this, if you include your house and everything you own, you may be north of $1 million. But that's not happened yet. But it could. So I'm still suggesting, unless you have a whole lot of money where you might want to have that authority rest in someone, there are ways to do that. You can do it through a third-party holder of a power of attorney that exists only for that specific purpose. So there are ways to write that in if you're fortunate enough to be in that situation. But absent that situation, I don't think you don't want to give anyone that power. Yeah, because kids will often think, and especially the one who's spending a lot of time taking care of you, that's the one who's most likely to be thinking to him or herself that, look, Dad would have wanted me to have the larger share. I'm the one who took care of him. I deserve it, yeah. Yeah, I was there. They weren't. They live in other cities. And I've done all of this, and this is what Dad would have wanted. And maybe even they ask you, in your incompetent state, and you and you say to him or her, well, yes, I appreciate so much what you've done. I want you to have it all. If you're incompetent at that point, then you don't want to be in a position to harm yourself, so to speak. Right. Now, let me make a distinction here that is worth making. When we talk about a power of attorney, we're talking about something that governs all your affairs except specifically health. Now, for health, there is a separate document. It's called a healthcare directive,
Healthcare directive,
or a
right.
durable power of attorney
yeah.
for healthcare is sometimes called. Different things in different states. I haven't spent time talking about that because often these are signed together. I mean, rarely. I can tell you, with most of the law firms that I know of that do estate planning, they're going to talk about these documents in conjunction because they kind of travel together, because in combination, they have you covered. But I don't want you to think, though, that you would always choose the same person. It's not unusual to have somebody different who's in the role of making the healthcare decisions, not financial, but healthcare decisions. So you may think that there's somebody other than the person you would choose for those financial and legal matters to handle those healthcare decisions. As a matter of fact, it's not unusual for that to be two contrasting skill sets.
Yeah, I would think so.
That's what we normally see.
Yeah. So with this power of attorney, you want them to have all the information they need to execute, paying your bills, running your life. And very often we see where people don't have access to that information. They don't know, how many bills you have coming in every month or, whatever the case may be. So you need to find a way to arrange that, I guess you could say, put it all in one nice little package.
Yeah, and it is, that's a good pivot point is I hope that we have sold you on the idea that you need a durable power of attorney. So I won't keep...
There's a takeaway. That's it.
I won't keep banging the table, so to speak, on that. But now you're raising the point that can't be ignored.
Right.
And that's that once you have this document in place, you can't just sit down and think, oh, thankfully I've taken care of that. Well, it is good. You can congratulate yourself for having taken that first step. But there's a second step that is almost just as important. And that's that you've got to have your information in a place that's fully accessible. It's very easy to name someone and then to go about your life. And of course, maybe you told them. Let's assume you told them, oh, I've named you as the holder of my durable power of attorney. And so they're aware of that. So each of you are going about your lives, and then all of a sudden they get a call from your child or a relative of you, calls them and says, oh, Bill has had a car accident, and you apparently have a power of attorney. So at that point, you're thinking, well, how can I be of help to him now? Yeah, I do have a copy of this document, but I don't know exactly where he banks. I don't know what securities he holds, what brokerage firm he's using. Maybe he's using online banking. Maybe it's Robinhood. Who knows what he's using in terms of websites to take care of his financial life. Then there's the personal information that he doesn't have access to. So you can see where you could very well, if you're the person who's holding the durable power, you could see where you're in a position where you have this powerful document that gives you a lot of authority, and all this is resting on your shoulders now. I mean, suddenly, your friend's life in a large sense of the word is on your shoulders.
And you don't want your friend to have to figure it out as they go along.
Yeah. And you don't want this person to be in a position where they're scrambling and they're frantic and they're still going to screw up because they can't. They can't know all the right things. So maybe some payment is due on a property you own that they don't know to make, and a foreclosure proceeding starts. Maybe your credit gets destroyed because this person doesn't know that you have these payments to Best Buy, that you had purchased something,
Yes.
Or some Visa card you have they didn't know about. Maybe they don't know that you use Apple Pay. There are things that despite their best efforts, I mean, let's assume you made the right decision. You chose somebody who's responsible and who's honest.
Mm-hmm.
but they can't read your mind. And the sad fact is, often somebody in that situation, the way they find out about things that people owe is when there's a legal action taken
You're absolutely right.
by a creditor or somebody else. Somebody there's sued. Maybe there's money owed someone under a contract. Could be an employee-employer relationship. They didn't know about it. And they find out when there's a lawsuit because you're suddenly going to be named as the legal representative to receive the action at the courthouse. So you have to find somebody to serve. And remember, you're alive. You're not dead. So when you're alive, you're subject to all those actions that everybody else is. Even when you're incompetent, you're still going to be the object of lawsuits and other proceedings just as you were before you were incompetent. Except now, you can't do anything about it. It's entirely in the hands of this person you've named. But the person you've named doesn't know that this stuff's going on.
And that can get really, really hairy. I can only imagine.
And you end up with a mess. You start out with good credit, a credit that we all work a lifetime to maintain our credit. Not to mention that we really intend to pay people.
Yeah.
I mean, we may care about them. We want them to have money. Maybe we were helping a kid going to college. I mean, all those things these little commitments we've made, but they're going to stop the moment that something happens where you're unable to manage it anymore, unless you have not only given someone this durable power of attorney, but you've also, as you said, we've given them the information.
Yeah, they need instructions. They need something to know how to run your life. Because you think about all the little details. This is true. I have this bank account that I've had since I was, maybe 20. And I've had the same car insurance. And they would always take it out of this account. And I've kept it all these years. And later on, as I owned a home, I used that specific bank account for State Farm to take it out. And you know what? And I make sure there's enough money in that account. But you know what? I don't think I've ever told my husband about. I mean, he knows about the account, but I don't think he knows that I use it for that purpose.
So now you've had the same bank account since you were 20?
Yes, this one. I mean, I have other bank accounts.
I know, but that's impressive. I can't say I have any account that I've had that long.
And I've kept it that long, and, it's changed, bank names. I don't know how many times. But you know what? Come to think of it, I don't think my husband even knows that that's the bank account that I use to pay for our homeowners insurance, our, vehicle insurance.
Yeah.
And so what if something happened to me? He wouldn't know that.
And that raises another point, too, is that illustrates the fact that often your spouse doesn't know everything. But keep in mind this, and I read this statistic some time ago, and I'll get this wrong, but it was amazingly large percentage of the cases when somebody is seriously injured or dies due to an accident as opposed to an illness, that their spouse is with them. So it hits both of them. So when you have catastrophic events, often husband and wife are together. So it's not at all unusual for both to be incompetent at the same time. And when that happens, then you don't even have the advantage you were just describing, where it's true that if you've named your spouse, and some of you now are widows and widowers, but those of you who are not, often you'll choose to name your spouse, which is often the right decision. But keep in mind, that second person you choose is critical because you just don't know. I mean, when you name your spouse, something could happen to both of you at the same time. And even if it doesn't, if you're older, maybe you're fine for a while, let's assume that your wife has a stroke, so you're in good shape, but in 6 months you're not. That statistic's scary. Something about long marriages, it's amazing. Either both will die within a year of each other.
I have seen that so many times.
Isn't that a weird phenomenon?
I really believe that you can die of a broken heart. And I think that's why we see that so often. I think one goes, the other one is heartbroken, can't live without the other one, and that's it.
That's an interesting thought.
Yeah.
So we do know, though, that that though you might choose to name a spouse, we do know that the chances are very high, whether it happens sooner or it's a few years, that just because you become incompetent first does not suggest that you will survive your spouse. So be sure, and not to mention your spouse can even become incompetent too.
Well, there's that.
Yeah, and then you're in really bad shape because this person has the power over your assets and they're incompetent. So depending on your age, you need to think about this. Some people will choose, if they're older, to not have their spouse as the first choice. It's not anything wrong with that. It doesn't mean that you don't trust your spouse. It's that you have concerns about your spouse's competency in the future. So many will choose a third party. And when you think about, though, what the characteristics of this is, we should probably take just a minute or so and talk about the fact that this person does not need to be a lawyer and they don't need to be a CPA. What they really need to be is honest, and they need to have good judgment, and they need to be willing to do this. And I use a stronger word than willing. Something between willing and enthusiastic.
Have your best interest at heart.
Having your best interest at heart. I think to ask for enthusiasm is asking too much. But something a little bit above willingness, I think you want. And I mean, let's think about, we were talking about this, and I was looking at some of the issues that are dealt with. And I mean, it's a lot of stuff for most people in this world. First of all, the websites and passwords. I mean, even your spouse probably does not know all the websites and passwords that you use. They wouldn't have. They have their own accounts. My wife has her own YouTube account. She has her own other accounts. So, there's no reason for us to share passwords. And there could be very useful information there for somebody taking over your life. Remember, this person is in the proverbial driver's seat. So they pushed you over, and now they're driving, and there's lots of stuff to take care of, and it ends up not being technically financial exclusively, and not being technically legal exclusively. It's the stuff that you would want done in your life. That's the person you want in this role, so that your life really does go on in a meaningful way, in a way that affects everyone else, and that despite your condition, remember you're incompetent at this point, despite your condition, you may still be in a position to have the peace of mind, the assurance that the things that are important to you are going on, and that's not just financial and just legal stuff. So when you think about the information on your websites, whatever you're using, and I'm thinking about more than Facebook, the brokerage accounts and banking, both on and offline, that's going to be driven by passwords and account numbers. What are your sources of income? You need to provide the names on the account. Remember, that's critical, because you may have a LLC, for example, that you're using. I mean, there are other names, entity names that lots of people use for different accounts. Maybe it's a business you started many years ago that didn't pan out and you kept it. So it's still showing with the Secretary of State of Missouri, it's showing as an LLC. And even though you think that it's your name alone, it's not going to be reported legally that way. So this person has to have the authority to be able to act on your behalf regarding any of those entities. Account number of those, and on sources of income, what are the methods of receipt? That requires details. The money that you do receive, what address does it go to? It might be that there are checks coming in that would not be received. Remember, this person knows nothing. So you may think, well, they know that I have this other place where I stay part of the year. Well, depending on if they're a good friend, of course they know that. But if they're not a good friend, they don't know that.
Right.
And this person doesn't have to be your best friend to be able to do this job well, a point we were making a while ago. Sometimes people will have an institutional representative do this. The most important thing is honesty and competence, not that they be your buddy. As a matter of fact, being a buddy has often gotten people in a lot of trouble in making this decision. So regarding debts and any recurring expenses, all the lenders, the payees, The name's on the account. Again, if it's not your name, then it may not turn up when this person does a search of your outstanding obligations. Account number, method of payment, and again, the details of where the payment.
Yeah, you think a lot of people are set up for that automatic bill payment, say with their utilities. What if somebody didn't know that?
And they pay it twice.
Yes, and I'm sure that happens.
And depending on who's on the other end, they may or may not be told that. So just real quickly here, I know we're running out of time. We just jotted down. This is just an example of a few of the things that this role will involve. Any significant asset should be listed out. I mean, we've talked about real estate, but it should be clear who the title of the real estate's in. Lots of people have real estate that's either jointly titled with somebody perhaps other than their spouse. They have real estate that is held in LLCs, not uncommon at all. Sometimes they'll be in a real estate trust. So you need to provide that information in a single place. Account numbers, or the name of the title, in lender info, loan balance. Again, you don't want foreclosure to start on anything you own, and you don't want a car to get repossessed just because maybe this person you chose had no idea you had an outstanding obligation on the car. So that's an example of an asset that you need to list: the lender information, including the account number and loan balance, the brokerage and tax-deferred savings accounts. List all of those. The institutions that they're in, the approximate balance. Reason the approximate balance is important on all these accounts is that among the most urgent period when this crisis that we're discussing here, when it arises, often that first 48 hours is among the most critical, because that's when things sometimes have to be paid quickly. Sometimes decisions like life flight and other things, they have to be done quickly. And if that person doesn't have the power to do it, then there's no one to pay for it. So being able for this person to be functional and to have liquidity, access to your funds is critical. And often that comes in the form of what's in banking accounts and brokerage accounts. So approximate balance should be listed. It doesn't matter to the dollar, but approximately. The name on the account, again, I can't tell you enough that the name on the account is critical for the person acting in this role. Account number. Similar thing with annuities and cash value life insurance. Often people forget about listing these things, and life insurance, even if it's term insurance, it has value, believe it or not. So some people just blow off their term insurance. Term insurance can be sold, not because it has cash value like permanent insurance. It's not that it has cash value. It has a market value. I mean, if you've had a stroke or something, the probability, I don't want to be depressing here, but an actuarial table might say that you're going to be dead soon, and your insurance has value. So that's not something you'd want someone to go to quickly, because it may be better to wait and have your loved ones get that $100,000 in full rather than sell it now and get $40,000 for it for somebody that's in this business, viaticals or whatever the business is called. But it's a well-established industry where that can be sold. So don't have someone foolishly stop making payments on your term life insurance. And I can't tell you how many times that happens. You die and the person, or you don't die, you become incompetent and the person who's in charge of it doesn't know to keep up those payments. Or they think, oh, well, that's $200 a month that we're wasting. I'm going to blow that off. And so they do, and guess what? There goes what could have been sold. If it were a $100,000 policy, it could have been sold for $50,000, for example. So insurance, all of that needs to be listed. The person you've chosen, you've got to give them an opportunity to be successful. Again, I'm assuming, as we talked earlier, you made the right decision, you chose the right person, they're honest, they're diligent, they want to do a good job. Don't handicap them in a way that they fail, not because of actions they did, but actions that you failed to do. And that's to equip them for success. And the annuities is a final source of income. And then also we mentioned the cash value life insurance. that's important to know too, because it's access to money, and that money can be borrowed. Because if you have your document drafted well, the durable power of attorney, it'll give this person the ability to be able to do things like access to borrow against the cash value. And what's wonderful about that is it doesn't disqualify your life insurance. You still have life insurance. The loan would have to be paid back. But if it's somebody that's got to access money quickly to meet a need that you have often in that first 24, 48, 64 hours, that sometimes is a place to get money quickly, depending on how your cash is arranged in your banking accounts. So we'll wrap this topic up here. We covered a lot.
We did.
But this topic deserves coming back to. It's so critical and so fixable. A lot of things are very critical and dangerous, but they're not so easily fixable.
No, they're not. That's why you want to be proactive.
Yeah, this one is one of those that doesn't cost you much to fix, and the benefits are just incredible. So hopefully we've sold you on that idea. This has been another episode of Life's Third Act. Till next time, take care.
You've been listening to Life's Third Act, a podcast for thriving in retirement, sponsored by TuckerAllen, your estate and elder law advisors. Each week, we discuss topics and answer questions to help you better plan for your future. For more information, visit TuckerAllen.com. Subscribe and listen again next week for another edition of Life's Third Act. The choice of a lawyer is an important decision and should not be based solely on advertisements.